A husband and wife may live in the same house for decades. They make the payments together. They pay the taxes together. They both consider it their home. Then one spouse dies, and the family discovers that only the deceased spouse's name is on the deed. Does the surviving spouse automatically own the house? In Texas, the honest answer is maybe, but you need more information. I'm Harvey Cox, a Texas estate planning attorney. In this video, I'm going to explain the documents and facts that usually determine what happens next. This is general educational information. Every family and every title history can be different. The first document to locate is the most recent recorded deed. You want to know whose name appears as the property owner when the property was acquired, and whether the deed contains any special language about survivorship. You should also determine whether any later deed was recorded. The couple may have transferred the house to a trust, signed a transfer on death deed, or made another change after the original purchase. Don't rely only on the county appraisal district's website. Look for the actual recorded deed. But here's the part many families miss. One name on the deed doesn't always mean that one spouse owned the entire house as separate property. Texas is a community property state. If the house was purchased during the marriage, it may be community property even if the deed names only one spouse. The source of the purchase funds, later payments, marital agreements, and other facts may affect that conclusion. Now, suppose the deceased spouse bought the house before the marriage. That may point towards separate property. The same may be true if the spouse inherited the house or received it as a gift. That distinction matters because community property and separate property can pass differently at death. The next question is whether the deceased spouse left a valid will. The will may leave the deceased spouse's interest in the house to the surviving spouse. It might leave the house to a trust. It could also divide ownership between the spouse and children. But having a will doesn't always avoid probate. A will is a set of instructions to the probate court. In most cases, it must be admitted to probate before it can be used to transfer the deceased owner's interest in real estate. That surprises many families. Without a valid will, Texas intestacy law determines who inherits. If the house is community property and all of the deceased spouse's children are also children of the surviving spouse, the deceased spouse's community interest will generally pass to the survivor, but consider a second marriage. The husband dies. His name is the only name on the deed. He has 2 children from his first marriage and no will. Even if the house is community property, his share may pass to his children rather than entirely to his wife. The wife may then own part of the property while her stepchildren own the rest. That may not disturb her daily life immediately. The problem may appear years later when she wants to sell or refinance the house. Separate property real estate has another set of inheritance rules. A surviving spouse may receive occupancy or life estate rights without receiving complete ownership. This is why blended families need to examine the title and estate plan together. Texas gives a surviving spouse significant rights in a qualifying homestead. Those rights may allow the survivor to remain in the home even when someone else inherits part of the title, but the right to live in a house and full ownership of the house aren't the same thing. A person may be protected from being forced out and still lack the authority to sell the property alone. That distinction often remains hidden until a title company, lender, or buyer examines the records. The mortgage doesn't decide who inherited the property. The deed concerns ownership. The loan documents concern the debt. The surviving spouse may continue making payments, but those payments don't automatically transfer the deceased spouse's title. The family needs to address both sides of the problem, the loan and the ownership records. First, don't sign a new deed or rely on a form found online until the title history has been reviewed. Gather the current deed, the deceased spouse's will and any trust, the death certificate, the mortgage information, prior deeds, any marital property agreement, the names of the deceased spouse's children, and information showing when and how the house was acquired. An attorney can then determine whether the family needs probate, an heirship proceeding, an affidavit, a trust-related document, or another procedure. Don't wait for a death. Pull the current deed and compare it with your will or trust. Ask whether your plan would leave the surviving spouse with full ownership, shared ownership with children, or only a right to occupy the property. Ask whether the survivor could sell or refinance the house without obtaining signatures from other heirs. The fact that both spouses think of the property as our house doesn't guarantee that the legal documents will produce the result they expect. The main points are simple. The deed is the starting point, but it may not settle whether the house is community or separate property. The will matters, but a will may still require probate. The family relationships matter, especially when either spouse has children from a previous relationship, and homestead rights may protect a surviving spouse's ability to remain in the house without giving that spouse complete ownership. You can read the related article through the link in the description. You can also download the Texas Probate Workbook to begin organizing your deeds, accounts, debts, and beneficiary information. To have your own deed and estate plan reviewed, schedule a consultation with my office. We can meet by phone, Zoom, or in person.